Hi friends from around the world, this is about damages. Today, moral rights and punitive damages as the main course. You know that the moral rights in case of copyright is not transferred to another person, right? You know that if the copyrighted work is being sold, the moral rights, unless it is said otherwise in the contract, remains always with the author. Well, the moral rights is something a bit strange in intellectual property, because in other IP rights, moral criteria do not really interfere. We have a possibility to reject a trademark on moral grounds, so to say, on absolute grounds, but this is the only thing where morality enters into play here. So that you know that is something, the moral rights is something very special linked to copyright. Now let's talk about the first case. This is from 2016 here on the screen, and it is about copyright. We have Liffers, who is the scriptwriter and producer, so to say the author of audiovisual work, Dos Cubas y Dos Patrias, or something like that. So that audiovisual work was being used by Mediaset and Mandarina. So another two companies broadcasted by Mediaset, and it included sequences of this copyrighted work without being in contact and without agreement on royalties with regard to the author. So that was in Spain, and the Spanish court in Madrid was seized with the issue on two grounds. So Mediaset and Mandarina was sued by Liffers on two grounds for damages. Well, the damages are the two grounds. One is on pure damages, so it was calculated on the hypothetical calculation of royalties on one hand, and on the other hand, that was 6,700 euros, and the other was 10,000 euros on moral damages. Now, the Spanish law provides both of it, and it has been transposed, its origin coming from Article 13 of the Enforcement Directive here on the screen. So you see that the damages can be calculated either subparagraph A on the actual loss, based on the actual loss, or including moral rights, or subparagraph B as a lump sum as what is the damages when it is difficult to calculate. Now, the first instance court in Madrid, it ruled that the damages are half in half substantiated. So they ruled that you get some 3,000 euros in damages for hypothetical royalty rights, and the damages in full for moral rights. It went to the second instance, where the moral rights were completely set aside, and the damages were reduced to something like 1,000 euros, and it still went up to the Supreme Court in Spain. So the Supreme Court had some problems with Article 13 and the consequential Spanish law, but it was about Article 13 of the directive, which is at the origin of the transposition into Spanish law, right? And the Spanish Supreme Court, they looked at Article 13 and subparagraph A and subparagraph 2 and said, well, if it is in subparagraph 2, then there's nothing on moral rights. So the moral rights probably are not being covered if it is based, the damages is placed on subparagraph B. And it submitted this to the European Court. Now, the European Court of Justice They looked at the context, and as always, when they want to have something being ruled in another way, a bit away from the wording, they would look at the context, at the recitals of the directive, etc. And they looked at this a bit, and they came to the conclusion, well, the context of the IPRED, the IPrights Enforcement Directive of 2004, is to give the right holder an effective protection for their rights and a compensation for their damages, for the loss and damages. And this is being in the recital and coming from the context, and it is at least, it is said in subparagraph A, at least it should be based on these different issues, such as the profit of the infringer, the loss of the IP right holder, etc. So it comes from that that the European Court of Justice says that subparagraph B can be chosen, such as subparagraph A, as a claim of damages. Now, it is based, if it is based on subparagraph B, so hypothetical royalties only, then although the wording is not so clear that moral rights should be included, in fact, it is not foreseen in that, it says, nevertheless, that moral rights can also be claimed. So the answer to the Supreme Court of Spain was that if it is the damages claim is based on subparagraph 2 of subparagraph B of Article 13 of the Enforcement Directive, then it does not mean that moral hazard damages cannot be claimed. So it can also be claimed, in this case, on subparagraph R. So what does that mean? Well, in effect, it is a bit result-oriented again from the European Court of Justice. They want to assure, so to say, a effective protection with regard to the IP rights holder, and the IP right directive, the IPRED, is practically the basis of the instrument which can be done. And it is possible if the second part, so the B, is being chosen, it should be chosen only in cases where it is difficult to make a more concrete estimation of the loss or the profit of the infringer, etc., where it should be used in paragraph A, subparagraph A. So B is a bit for special cases only, but it is possible also to get the moral rights. So this was one of the damages, the court judgments of the damages, and there's another. This case, a Polish case, so to say, if you want. And the situation at origin is more or less the same. So is the broadcaster, and there is a CMO, on the other hand, as a claimant, which sued the broadcaster for having broadcast a copyright-related and copyright-protected content. Now, that is about punitive damages, and the Polish law foresees punitive damages. Punitive damages meaning that you get to punish the infringer in a way that he gets to pay higher than, so to say, the actual loss. So he gets a certain kind of punishment, financial punishment, in order to deter the infringer from future infringements. The punishment, this kind of punishment, punitive damages, whereas it is, for example, foreseen in China, European law normally do not foresee punitive damages. So it is rather in Europe, in European law, it is rather about compensation, compensatory damage claims, compensation damages, rather than punitive damages. But there are some member states where it is foreseen, and Poland is one of them. It foresees in its internal law that the punitive damages can be applied and can be the double of what would be, so to say, the normal damages, the compensatory one. And it went, well, it was in front of the court, and the court, they wanted to know whether the punitive damages, whereas there's nothing in the IPRIT, in the IPrights Enforcement Directive, whereas nothing inside, whether the Polish law would be compatible with this enforcement directive. So what is it about? Interesting enough, it went to the Court of Justice again, referral court, right, to Article 267 of the European Union Treaty. And then the court, well, before the court there was the Attorney General. And if it is a case, you know that, if it is a case which has a certain importance, the Attorney General is being asked for its opinion. And the Attorney General, in that case, it said, well, it is a bit outside of European law to have foreseen punitive damages. It is rather a compensatory system which has been construed around the European law. Therefore, it should not be probably be compatible with the enforcement directive. Now, the European Court of Justice, although more often than not they follow the Attorney General's opinion, in this case they decided not to go along. They said punitive damages, well, it can be because the enforcement directive, as it is a directive, foresees only minimum standards. You know this already. So that the member states, if they want to, they can go further, they go beyond of these minimum standards. And the Polish law, by foreseeing that it can double what is to say the normal damages for compensation, it said, well, that is still within the margin of the member states which can go beyond the minimal standards set by the enforcement directive. So this is about the two cases I wanted to talk to you. There's another case here on the screen, which is on plant varieties. Now, I didn't mention really plant varieties because I don't think that is so much of importance from you lawyers, mainly from around the world. Therefore, it is a bit set apart. But still, there was a question in front of the European Court of Justice. So again, it went up all the letter to the highest court in the Europe, where it was being asked whether punitive damages could be applied to that case. And again, in its point 38, the European Court of Justice, they said, well, punitive damages is not something really which is about European law. So it is a bit contradictory to what we have seen in the judgment before. But they say what I initially said, but that the punitive damages is not something what we foresee in Europe as such, but it is possible for the member states, as we have not completely, we have a certain harmonization, but it is not one law in the whole European Union. It has still to be transposed, and there are choices for the member states to go in the one or the other direction. Do you have punitive damages in your home jurisdiction?